Senate Bill 850, or Senate Bill, House Bill 851 is the bill that's already been put on another House bill via the amendment process on the floor, and it should be sitting over on the other side of the building. But what it does is places caps on the contingency fees in which, when the Attorney General farms out work and hires a law firm or an attorney to do work on behalf of the taxpayers in the state of Missouri, it places caps on how much the contingency fees can be paid to that firm or attorney.
Feel free.
Proceed, gentlemen.
Thank you, Mr. Chairman, members of the committee. Thank you for your consideration of House Bill 851. For the record, I'm Alex Kirchin, representing the Missouri Chamber of Commerce and Industry, and I'm here today to testify in support of House Bill 851. A little background on this issue. In 2011, the House and Senate passed House Bill 111 and Senate Bill 59, which laid out the process by which the state contracts with attorneys with private attorneys for contingency fees. The bills required the Attorney General to make a written determination first and prior to the contract being issued that the contingency representation is both cost effective and in the public interest. So the House Bill 111 and Senate Bill 59 further require that the AG request written proposals from private attorneys to represent the state if that determination that the fee arrangement through contingency is cost effective, and then required them to put that put in writing requesting proposals from those attorneys. Any bid that's selected in that process is required to be the lowest and best bid, and that's under current statute, which is the statute you see today, which is in Chapter 34. Among other requirements, the procedures also required the Attorney General retain complete control over the case in all settlement negotiations, as well over the course and conduct of the case. All public disclosure regarding the contracting of the case is also handled by the Attorney General and his office. And finally, the Attorney General was required to submit an annual report by February 1st to the House and Senate describing the use of contingency fee contracts with private attorneys in the preceding calendar year. And those reports are filed with the Speaker of the House and the President Pro Tem and filed generally in the Legislative Library. So the bill before you today is another issue that extends the provisions the legislature passed in 2011, and it protects taxpayer dollars to ensure that the settlement or award proceeds on state cases make it to the state and victims and is not eroded by attorney's fees. And the idea of a fee cap on attorney's fees isn't a new idea. Numerous states place limits on attorney's fees, most often in the areas of workers' compensation, administrative cases, or administrative claims. Regulating the fee contracts are perfectly within your purview and firmly within the jurisdiction of the state, as essentially the state is contracting with the attorneys. In the past decade, the number of instances of outsourcing of legal services has grown and increased, and a large reason of that is because of tighter state budgets. And certainly, this bill isn't a reflection or an instance where contingency fee agreements aren't proper. Contingency fees arrangements are proper with outside counsel with the state, and that's not something this bill would contest. But what you have before you is a balanced approach that preserves the ability of the state to negotiate and contract with outside attorneys, private attorneys, while protecting themselves from political pressure and furthering the state interest in maximizing the award in such cases. 13 other states have enacted similar legislation in recent years, and we believe that it will be advantageous to the state of Missouri to do so as well. I'd be happy to answer any questions.